fair value and liquidation value. So as it's clearly saying that currently there is a requirement of appointing two valuers, two registered valuers for determining the fair value and liquidation value of the corporate debtor. Here we're talking about liquidation value and fair value of the corporate debtor, because we're talking about the process of inviting request is RFP process. When we go for RFP process, we issue an information memorandum. For the purpose of information memorandum, we talk about the values of assets, and those values include both liquidation value and fair value, but the reserve price is based on the fair value. Fair value, of course, assumes that the entity will remain a going concern, whereas liquidation value looks at what if the entity was to go into liquidation. What Shrikant, if you can kindly, Mr. Shrikant Jawar, if you can kindly mute yourself. And my request to Shrikantji, kindly mute. And my request to the host, Anjali Madam or whoever is hosting, please mute all participants unless I mean you can keep the option of unmuting to yourself. So upon entry, the participants are muted automatically. Therefore, we don't get disturbance as we move. Of course, ICSI, if you are right, and the host, if you are listening to me, kindly mute all participants upon entry. If need be, we can. Okay, I'll probably unmute myself. Right. Right. So, and ICSI, whoever is hosting, maybe Anjali Madam, if at all people need to interact, I'm sure they'll need to interact. At that stage, they can do a hand raise based on which we can unmute and then allow people to interact. So I was mentioning that we, as of now, appoint two registered valuers for determining the fair value and liquidation value. And IBBI says that this is not exactly in sync with the valuation rules under the Companies Act, because registered valuers come in terms of companies registered valuers and valuation rules, which are rules under Companies Act. And that rule actually says that a valuer may, if he so requires, appoint other valuers for specific assets. I mean, the essence is quite simple, that if someone is appointed to value, for example, let's say building and a machine and let's say shares and securities, I might have a specialization on shares and securities. I may understand nothing about valuation of buildings. Whereas if I may understand valuation of buildings, but I may have nothing to do with valuation of plant and machinery. Therefore, valuations of different assets require different skill sets. I may be a large valuation firm. I might have expertise in each of these assets, but very often a valuer may be lacking expertise in every particular type of an asset, which may be forming part of a corporate debtor's umbrella of assets. In that situation, the discretion is with the valuer to appoint other valuers if he so chooses. That is, he can rely on the report of other valuers which may be appointed by him. In essence, the company appoints one valuer who in turn may appoint other valuers if he feels it necessary. So in line with this power of a valuer, what IBBI is proposing is that in case of those, so in order to streamline the process, remove ambiguities, is proposed that CRP regulation may be amended to specify the RP shall assign for carrying out valuations of CD as a whole to the RV. That would mean the RP will appoint just one registered valuer. Instead of two valuers, the RP will appoint only one valuer. And that valuer in turn, if he so chooses, he will have the option of appointing other valuers from whom he may get, reports on sections of assets. But as far as the RP is concerned, the RP will get one valuation report from just one valuer. Currently, the practice is that we appoint two valuers, and if the values are significantly different, then we appoint a third valuer. And therefore, if we are appointing two valuers for, let's say, third valuer in case of distinction, then for different classes, we might have several valuation reports. So to avoid that multiplicity of valuation reports, the proposal is just to provide for one valuer, and this one valuer, if he so chooses, he may in turn appoint other valuers Of course, this valuer will provide both liquidation value and fair value. So why is IBBI talking about 2 into 3? 2 into 3 because if there are differences in valuation, then we're talking about 3 valuers, and each of the 3 valuers are computing the fair value as well as liquidation value. That's the proposal. Therefore, henceforth, once the proposal is given effect to, it would be possible for the RP to appoint just one valuer who will compute the fair value and liquidation value both. And this valuer, if he so chooses, if he so requires, he may in turn go to other valuers to get their reports. But the valuation report submitted to the RP will be from just one single valuer, giving both the fair value and liquidation value. That's the proposal. Does anyone have any comment on this proposal? Anyone who has any comment at all, any contribution, any, are we largely, I would say personally, I would be inclined to agree with this, and therefore I'm sort of object to this change. But let's hear Mr. T. Ranganathan. Mr. T. Ranganathan, kindly say. Yes,
actually, when calling for the quotes from the valuers, it is not just one valuer the RP is appointing, though he may appoint only one valuer, he will call for quotes from multiple valuers. To know whether he has the strength to tie up with other valuers, at the time of calling for quotes itself, they have to submit those who are willing to associate with himself, with the prime valuer for the other asset classes. Otherwise, the process will get prolonged actually. After his appointment, he has to go and tie up with other valuers, means it will get the process to be delayed actually. That is my suggestion only. At the
so, Mr. Ranganathan, yes, sir. Yes, sir. Point well made. Now, the way I see it is that if the RP in question invites proposals from different valuers, and the valuer, while submitting his offer, he knows that he will not be able to do it himself entirely, and therefore he would need the assistance of other valuers. I'm sure while he is giving his proposal, he would have factored the the cost of the other valuers himself. In a sense, he would have captured how much he will be required to pay to other valuers while he is giving his own proposal. So at that stage of proposal itself, it should be made clear that the cost that you are quoting includes cost of other valuers in case you feel it necessary to get the specific assets valued by other valuers. But having given his proposal, the valuer then cannot turn back and say that, hey, I had not included the cost of other valuers, therefore my quote will go up, because otherwise the whole basis of appointment will get disturbed. So, Mr. Ranganathan, the point you made is valid. Therefore, what we should suggest to IBBI that at the stage of inviting proposals, make it clear that if at all the valuer has to engage the services of other valuers for the purpose of carrying out valuation, he should factor those costs while giving his proposal itself. I hope that addresses the point, Mr. Ranganathan.
Mr. Kothari, who is the final authority? Because in practical, the COC member is telling that we will appoint from our legal. So who is the authority to appoint RP or COC?
I think usually during CRP process, the decisions on professionals are taken by the COC. The RP will put the proposals before the COC, and the CSC usually decides. I think that's typically the process. I mean, the RP is simply the master of the ceremony. He's a kind of one who's conducting the whole show. He's not taking decisions himself. During CRP, the decisions are taken by the COC. That's the usual understanding. During liquidation, things are a little different because there is a consultation committee, but not a committee of creditors, stakeholders committee, but not committee of creditors as such. The power to decide during liquidation is with the liquidator, of course, based on consultation with the stakeholders. But during CRP, the decisioning is largely left to committee of creditors. That's the usual understanding. However, that's not the point for discussion here. The decision-making powers are already clear in the CRP regulations. Here, the only point is instead of two, the IBBI is suggesting only one valuer. So the RP gets only one valuation report. Therefore, the question of difference in values and therefore going for third valuer.
Yeah, Kothari. Hey, Aniket. Aniket.
Yes, sir. Whoever is speaking, kindly speak.
But I think all the assignments will go to a RVE instead of RVs by with this amendment. Individual RV will hardly be getting any assignment, and there will be a lot of logistic issue if RV are getting appointed,
Sound क्यों
because
नहीं आ रहा?
each people will have their valuers will have their individual requirements. So first they will communicate to the principal valuer, and then the principal
ये
valuer will communicate to the RP. So that is also going to be challenged. So it means the IBBI only wants RVE to do the valuation and exclude all the individual registered valuers.
ICSI, my request to the host once again, while you are permitting the participants to unmute themselves, is leading to an overlapping sound. So please do it. Let the power of unmuting be kept with the host, so the host can unmute one by one. So Mr. Rasik Singhania's point is that this may discourage individual RPs from acting as valuers, and business may therefore get concentrated in the hands of RVEs. Well, Mr. Singhania, to an extent, you have a weight in your point, but probably it's. I mean, the counter argument could be that even an individual valuer may seek assistance of other valuers, include those costs as a part of his own, I mean, estimate, and then he may carry out the entire assignment after getting the benefit of contribution from other valuers. While that may be a counter, reaction, but the point that you're making is valid. We'll probably put across this point as we give our feedback. Our job here is to give a feedback to IBBI. Our job is to collect feedback from participants and give it ultimately to IBBI. So Mr. Singhania, point well made. Mr. Divyesh Desai, can you and host make please unmute?
So my observation is on similar line as Mr. Singhania, but I would like to add that if it is made mandatory that only one valuer is to be appointed and he may coordinate with others, this may, I mean, sort of chances of RP to select a valuer who, according to him, may be good in each categories is reduced to that extent, because then
That's right.
he may be able to deal with only one or two guys. So it would probably reduce into the choice. So rather than this making it as mandatory, if it is made as optional, because managing one report or three report, I don't think RP has any problems. So if it is kept as an optional with the RP to decide whether to go for one valuer or for each category separate valuer, I think that may be better, because it may be he can select, pick and choose the good ones, and also maybe try to reduce the cost also.
Mr. Desai, your point is well made. I think Mr. Singhania was also trying to say the same thing, but you probably placed it better. You are saying that because one single valuer may not have expertise in many aspects, and therefore this would actually, necessarily force assignments to go to larger firms which have multiple valuers as a part of RVE. So the point is well noted. Some of my colleagues
And
are.
my suggestion is that rather than making it mandatory, if it is kept
Keep it
optional
Correct.
for the RP.
Sure, we'll note this point. One of my colleagues is taking Neha or someone is taking a note of the points which are coming. I think that would be helpful. So we collate the notes and ultimately give it to IBBI. In fact, ICSI IPA. Mr. Pankaj Dhanuka, if you can.
Thank you.
Thanks, sir.
Sir, I had a related question, may not be the direct question. Who is responsible for the accountability of the valuer? Is the RP at all accountable if supposing there is a question on valuation later on, there is a case against the valuation key, it was higher, it was lower, or whatever, it was A was not considered, B was not considered, C was not considered. So who will be accountable for that? Because in my case also that happened. And when I go to NCLT, I am seeing there are cases where others or even the old borrower is filing a case against the valuation itself. So is the RP accountable? Yes or no?
I think Pankaj, well, it's not my. I'm not the right person here to answer the question. But the way I feel is that you are appointing a professional. You are appointing a qualified professional who is recognized by law and also recognized by the relevant professional body to do valuations. If all details which are required by the valuer are provided correctly by the RP, your job is to provide details. Details having been provided, the valuation is done by a professional. RP cannot be responsible for the act of another professional. RP is a professional, similarly valuer is a professional. I don't think the RP can be held to or can be accountable for valuations done by the valuer. But of course, if there are some factual gaps in the facts provided by the RP, then there could be probably a issue there. Mr. Sumit Gupta, if you can kindly, Pankaj, you would have a follow-up.
Sir, just an additional point here. So in the proposed amendment, can it be written that the responsibility would be of the valuer rather than the RP?
We'll place it as part of our recommendations, Pankaj.
Right.
Mr. Sumit Gupta, sir, any? Yes, sir.
Yes, I have an extended question to what Mr. Pankaj has mentioned, who has posed his question on the RP, the responsibility of the RP. So my question is, about the responsibility of the RV who would be, giving the valuation report based on the report he would be securing from the other two categories of the values. Like, suppose that, RV appointed is belonging to the SFA category, right? And he is supposed to take the valuation from other two categories, the PNM and the LNB. So now the point is both the other category valuers are also belonging to the, the IBBI, registered valuers are there. And, taking the whole responsibility by the RV belonging to a category of which is not a technical person, and based on the report of the other two valuers, other two category valuers, now he has to issue that report and he has to take a call. So we can take it as like the responsibility of joint auditors in case of financial statement, right? So my question is, whether there is tomorrow there is a questioning regarding the valuation in at any forum, maybe NCLT, maybe any court of law. Will there be any kind of responsibility of the other two, valuers, because they are belonging to the same regulator? And since they are the technical person, and but they can very well explain, the methodology and the other basis of valuation they would be submitting. Because as a SFA valuer, the main valuer or the principal valuer has to rely on the report as a professional, because he cannot deliberate. He can only rely. Obviously,
point is well made. Point is well made.
Question he may put up, and the responsibility will lie to him, but he will be relying on that.
Right. Point is well made, Sumit. So I think let's phrase it this way: that there is a primary valuer, which is what the RP appoints, and there are secondary valuers who are appointed by the primary valuer.
Right.
So the point is that the responsibility should lie on the primary valuer, not on the secondary valuers, because eventually the assignment was taken by the primary valuer. We'll make this point, Sumit. This is a point well made. So let's note this point and take it forward and as one of the recommendations to ICSA IPA. Mr. Kashi Vishnath Shivaraman, sir.
Sir, this is with regard to related parties of the RV. Can they be appointed? For example, a valuer is appointed and he appoints his own relatives. Can it be done?
Normally speaking, I'm not aware of the professional ethics as applicable to RVO. After all, it's coming under RV rules. But usually speaking, when it comes to any conflict of interest, usually any professional should avoid any conflict of interest. If at all conflict of interest has to be there, it should be disclosed to the client. So in this case, the RP will be the client. And if the RV is appointing, the RV is appointing his own related party as another RV, he should do a disclosure to the client. In this case, the RP normally, I think this should actually be avoidable. That's all I would have to say. But because I don't belong to valuation professionals, I'm not sure whether there are rules in the RV valuation rules which prohibit a valuer from getting into conflict. But usually speaking, general rule is that any conflict of interest is always avoidable. But we'll flag this point also, sir, that there should be no conflict of interest in appointment of the so-called secondary valuers. Raj Kamalji, if you can kindly. Thank you, sir.
Thank you, sir.
Thank you, sir. Raj Kamalji.
In extension of the point what the previous speaker told, the RP needs to take a disclosure of interest, disclosure of relationship from the appointee. Now he will be taking from the principal valuer whom he is appointing, and the secondary valuer whom they will give, whether they will give to the principal valuer or they will give to the RP. that needs to be ensured because the relationship is required. As far as the conflict of interest is concerned with the CR, with the corporate debtor or the RP, that he cannot be appointed. But as far as the relationship with the RV is concerned, I don't think that should be stopped, because that conflict of interest relationship needs to be disclosed with the corporate debtor, whether he was appointed as a auditor or not, or there are so many points. If any relationship with the valuer himself is there, then that should not be but that should not be the point of disclosure. That is not my point of view.
Got the point, Rajkamalji. We noted the point that if at all the primary valuer is relying on reports of secondary valuers, because he's anyway relying on that, and that will form the basis of valuation report. So if at all there's a relationship between the primary and secondary, then the relationship should be disclosed to the client, who in this case will be the RP. So it's not a point under CRP rules, it's a point under valuation rules. And we are anyway stating the point that adequate disclosure should be done to avoid any conflict of interest.
So the disclosure with the corporate debtor also needs to be disclosed by the secondary valuer also.
If at all there's a relation with the CD, that's what it's
saying. Yeah.
I think that's very apparent. That's a valid point, that if at all there's a relation between the primary valuer or the secondary valuer and the CD, that should also be disclosed. So because that is one reason for conflict of interest. Point well taken. Right, Rajkamalji. Right. So if there are no other points, I think we are generally in favor of this, with the caveat that this can actually be made optional rather than mandatorily stipulating for the appointment of one single valuer, because that may lead to only larger valuation firms getting an advantage. Second point, which is Mr. Ranganathan, you would like to say something further, sir?
Yes, sir. This can be categorized based on the value of the company under IBC.
Like the second.
If it is a smaller thing, you can do it. If it is a bigger thing, you need a separate value.
This is exactly what they've done for second recommendation. It's based on asset size. So maybe similarly for the first point also, it can be made optional after a particular size. That, for example, above 1,000 crores may be optional rather than mandatory. Sir, Mr. Shuraman, you were saying something further?
With regard to, sorry, one small point. Lost the point.
You can come back. No issue. Yeah.
No, for example, if only one valuer, can the COC appoint two valuers?
So as it's currently drafted, it seems to be saying that there'll only be one valuer. That's how it's currently drafted. But like a lot of participants mentioned, we would like to express the view that above a particular size, this may be more of an option than an obligation.
Sir, what could be the criteria? What could be the objective of drafting such a regulation, new regulation? Was there any default or some kind of apprehensions with regard to the previous regulation earlier? What is the benefit actually we are getting in this?
They're mentioning that this is leading to multiplicity of valuations, and therefore supposing we wait for two valuations first.
But in any case, that multiplicity also is not reduced here, because it is open for the primary valuer who is getting appointed. He has the option to appoint a couple of other valuers in case he requires.
Yes, sir. So the way
multiplicity is not being handled in that case.
So by way of reaction, sir, what's currently happening is that we appoint valuer A and B. Correct. And then we wait for X number of days. Ultimately, we find that the two valuations are quite different. And then we go for valuation C. So these two are not consecutive. These are sequential. We first have two, then we got a third one, if the values are different.
Yeah, only if it is different. Yes.
And quite often they are different. I mean, in reality, they're very often very different. Now, what is now proposed is that we appoint only one valuer. That valuer in turn may go to two other valuers if at all he chooses. But when he submits his report, we are only getting one valuation report. So the question of any discrepancy, difference in values, and then going for a third valuer, that will get avoided. Maybe this is just a way to speed up things. I think that
maybe the cost could
cost,
also be
more than cost. I think speed. After all, I don't think valuation is that I mean, of course, for point number 2, they're talking about cost.
Yes, not much
Sometimes
fees
yes.
are, they are in the trend.
Right. But point number 2, they're talking about cost. In point number 1, I think
But,
it's primarily the fee,
Sir, for MSMEs, cost could be a factor because
which is why
MSME
correct. That's number 2, where they're talking clearly on cost. So in point number 2, they're talking about assets of certain size, and there they're saying that for companies with assets of certain size, they're talking about 1,000 crores worth of value as per last available financial statement. Asset size of 1,000 crores as per last available financial statements, or MSMEs. Sumit, would like to say something further?
Let me share. Actually, I have attended one more webinar regarding these amendments, and I have shared that this proposed threshold of 1,000 is still a large, on the larger side, and I think 200 or 250 CR, I think is a a rational kind of threshold wherein this proposal can be made, to appoint or to give the option of appointing more than one RV. So I think because even the size and the complexities that would be there, that would be more in case of a company having.
One moment, there's a disturbance coming. ICSI, kindly, wherever you kindly see a noise, please mute participants. Okay, Sumit, sorry. You are saying instead of 1,000 crores, this should be made 250 or something.
Maybe 250 or 200, whatever rational,
We'll put this recommendation.
Because the complexities in a company, having an asset size and what kind of asset could be there, whether tangible, intangibles, and that should be made clear in the final the regulations in this regard.
To my mind, they are referring to the last available balance sheet, and therefore they are talking about whatever values there are in the balance sheet, whether tangible, intangible.
So balance sheet is definitely a correct thing to look at, the last balance sheet. So my question is, asset size they have mentioned, and it should be clear whether they're talking about all kind of assets or the tangible, intangibles, because valuing tangible assets of that size, 1,000 crore is a big amount, and making it 250 and having intangibles, because valuing intangibles and tangible assets is altogether a different ball.
Got it.
So that clarity should be there, I think.
But I think in the draft regulation, they're referring to asset value as per last available balance sheet, which means whatever assets there are in the balance sheet, we are taking values as per balance sheet. We're not getting into, I mean, excluding or including certain assets.
No, not excluding. So my again, so just to clarify, so having an intangible on a balance sheet, let's say 900 CR of the intangibles and 100 tangible. So the complexities would be lesser there, in my view, in case of intangibles, because you need not do any kind of physical verifications or the visit to the sites. So let's say a case of a real estate company wherein 1,000 crore assets would be a sizable amount, and valuing that by a land building or a plant and machinery valuer, the machinery involved and the the real estate assets involved therein would be a time-taking, time-consuming exercise, and definitely the cost would be according to that. And valuing an intangible by an asset category or any kind of other category of valuer would be something different, and cost involved and the effort involved from the perspective of an RV would be different. So that's what I'm saying. That so my view is that clarity should be given, and the option should be given accordingly. The 1,000 crore is still the threshold, or if it is lower then clarity again can be given accordingly.
Right.
That's my view.
Right. And Mr. Ranganathan, you raised your hand again. Would you like to say something?
Yes, sir. According to proposal in 2.3, IBBI has proposed only one valuer to be appointed for asset size up to 1,000 crores. Only if COC decides to have two valuers, they can go for two valuers. Actually, the purpose of having two valuers is to have a value determined unbiased. In case of discrepancy, we can also go for third valuer also. So to have the correct valuation only, they have proposed originally two valuers. They could have done it with one valuer also. By dispensing with two valuers and leaving it to the discretion of COC, the value may get diminished for the corporate data. That is my observations. In case of any, even now in liquidation, if we are selling an asset, we are taking the average of two. No. If there is only one value, you will get a lesser realization also.
So you are not in favor of this change.
Yes, yes. It should be two valuers. One valuer will take care of all the asset classes. That should be fine.
Right. So we are getting a mixed view on this. So I think we'll state it to ICICI IPA that there is a mix of views. Some people are recommending that the existing position may continue. Let's move to the third, which is more in case of class of creditors. Here, what is proposed is that as an authorized representative of a particular class of creditors is appointed, the appointment of the AR has to get the approval of the adjudicating authority. And that may take time because the AR has not yet been affirmed by the AA. In the meantime, if meetings of COCs happen, the AR is not able to attend the same. So the proposal is that once the AR has got maximum vote of the FCs of a particular class, such AR should be allowed to attend COC meetings even pending the confirmation from the adjudicating authority. Personally, I would think this is quite a fair proposition because once the highest votes are very clearly in favor of a particular AR, the confirmation by the adjudicating body is more a matter of formality. So I would have actually suggested that the requirement of confirmation from the AA can be dispensed with completely, because if highest votes are there, then the AR can directly be appointed as such. But they are recommending that while the confirmation will still be required, but in the meantime, the AR with the highest votes may continue to act. That's the proposal. If somebody has any views on that, kindly share. I believe this is more uncontroversial, and therefore I don't think people are participants are opposed to this change.
I think agreed with your suggestion, Kothari, that ideally it should be dispensed with the AA's approval, where it's very mechanical. It adds to the cost, it adds to the time, effort for everyone. So
more importantly, it adds to the burden of an AA. AAs are already burdened. Why give them additional?
It's very routine kind of an AA. So ideally, we should recommend.
But there'll be 6 even for a routine thing. There'll be 6 adjournments.
Possibly, yeah.
So the whole issue, the idea basically is to declog the AAs. They already are sufficiently burdened. Let them be burdened with matters which require their adjudication.
Correct. Because here there can be no challenge if they are with majority. So I think
this is a non-adjudicative task, and this should be therefore automatic. There is nothing to adjudicate when there is
provision to change AR if the any class of creditor thinks of that. So I think that's an option anyway available.
Right. So that's what we will recommend, that in our view, the regulation itself may be amended to avoid the confirmation from AA. Mr. Ranganathan, you had something to say, sir?
Sir, it is only a suggestion on this score. AA at the time of admission order itself can, if there are class of creditors, can appoint one insolvency professional from the panel itself. It will. No. Sir, actually, when the admission order is passed by the AA, they can actually appoint one insolvency professional from the panel itself. So the time taken will be reduced much. So then approval also will be granted earlier. So this complexity will not arise. A person who is not appointed by the authority, how can he vote? Legally, you are a legal person, you can tell.
Sir, I don't think it would be possible to appoint an AR at the stage of admission, because at stage of admission, we don't even know which all FCs are there. Claims will be invited only subsequent to admission. And we don't even know what is the voting share or what is the wishes of the FC. After all, the AR is supposed to represent the creditors. Who is the most appropriate person to represent a particular class is to be left to the class instead of the AA overriding with its own decision. And as sort of an interim person, that until the FCs appoint their own AR, somebody appointed by the AA will act as an interim AR.
Okay.
Someone like an interim AR. That could probably be a stopgap arrangement. But I think, as Mr. Sumit Gupta also mentioned, that in fact, Mr. Desai also mentioned that if highest votes of FCs are there, then there is no reason to invoke the jurisdiction of AA for something which is completely.
If there are any action against the IP, they have to check. Normally, that is the reason why they reject. there is any disciplinary action is pending against I. That is the only ground they can reject the
Then that
appointment.
is more for the IPA and IBBI. If at all there is an action or any kind of proceeding, let's say there is authorization for business is missing, or let's say there is show cause against the RP, then that's for IPA and IBBI to administer. I don't think the A will have. I mean they don't need to interfere in such cases. That's where ICICI IPA or the relevant IPA and maybe
The
IBBI can.
RP will check that class also
Or-
before appointing the
And maybe
yeah,
he will self affirm that I am eligible to be appointed.
self-declaration.
Right.
Yeah.
Right. Yes. So I think these were the 4 proposals for CIRP. We'll now move to the next set of proposals, which is pertaining to liquidation regulations, which is primarily dealing with just one change. That's the format of the progress report. So let me open that and come to the format of the progress report. This one is suggesting a very detailed format of progress report. Currently, the regulations lay down the contents of progress report. Regulation 15 is laying down the contents. It's not giving a format as such. So the contents are anyway listed out here as well. The details of, so these are the contents currently. These are the contents of the progress report. There's no format as such. But IBBI is of the view that to streamline the process and ensure uniformity in the structure of the reports filed by liquidator before the AA, it would be beneficial for IPs if there was a standardized format. And they're now suggesting a standardized format, which is a sort of most of the fields are mandatory there, which means you anyway have to fill up the mandatory sheet. And the format is, of course, based on the contents given in Regulation 15/2, but it's now getting into more like a web form kind of. It's like almost like an XBRL kind of a form where you need to fill up necessary items. It probably would be machine readable as well. Other than the fact that there is a standard format, therefore diversity of progress reports will be avoidable. But I will, to that extent, any standardization process is normally recommendable. But in terms of throwing an additional burden on a liquidator, I'm not sure how would any of you would react. But let's run through the contents. First part is details of corporate data, which is, of course, details remain the same every progress report. Synopsis or brief facts about the case, including reason for commencement of liquidation process. Let's understand that after all, it's a progress report, and progress reports are filled in periodically. Some of these items are completely static because reasons for liquidation, for example, will not change period after period. It's actually not a part of the progress report. Basically, is what steps have you taken during the reporting period. What is the work done by you during the quarter? You are reporting on work done. Things like what are the details of corporate data may be necessary to identify the corporate data. But for example, item number B, which is synopsis of the, I mean, why did liquidation commence? This is not a part of the progress report. C, of course, present status of the process. Where are we currently? Reasons for pendency, proposed line of action.
Sir, Kothari, just
Yes.
I think this part B, can be made, as a disclosure in the first progress report. I think. I mean, it can be recommended to IBBI so that the A could check from the records wherever the progress reports are there to recollect, because it's not possible every time when the progress report is checked or discussed at any stage in the liquidation process.
In other words, item number B should be reserved only for the first progress.
Only the first progress report, so that the synopsis are there instead of looking at the order of liquidation. Obviously, the adjudicating authority would have given the liquidation order itself.
Right.
And
ideally, in fact, ideally, sir, it could be part of the preliminary report. It need not be even part of any progress reports, but it could be part of the preliminary report. So
you're actually correct. You are actually right. This should actually be part of preliminary report. The preliminary report is the place where region. I think that's, my colleagues can maybe list this. It's a very important suggestion that item B can be part of preliminary report rather than progress reports. Present status, I think, is any important order from the authority other than AA, and reason for pendency proposed line of action to complete the liquidation process. What is the current state? If we are overshooting the timelines, what are the reasons for that? That's usually anyway there in a progress report. List of events during the taken during the liquidation process, that would obviously relate to the particular reporting period. From LCD to previous progress report and during the current quarter. So once again, part 1 from LCD to previous progress report is like a cumulative list of events. This will keep adding every quarter. So I'm not sure whether this is also serving purpose. It may be only relevant for the purpose of like a reference. Then instead of opening previous reports, we could probably get a complete snapshot in the present report. But number 1 will continue to accumulate every time. Number 2 is what is actually the list of actions taken during the quarter. Number 1 is more like a inventory of existing events. Any thoughts on point D? Mr. Desai?
Actually, my experience is that whenever a progress report is heard at the NCLT adjudicating authority level, they are only keen to understand what has happened in that quarter. They never go into details of what has happened from the beginning, otherwise it complicates the matter. So ideally, if the progress report is kept for the development during the quarter, I think that's the best thing.
Mr. Desai, you mentioned that NCLT during hearing they are interested to hear on the progress report as well. Are you saying that there are hearings on this?
IA is of course heard because you have to file it as a part of
as an IA.
As an IA. So when that IA is listed, the generally judges would like to know what has happened in last quarter, whether there is any progress, there is no progress, but they never go into details from the beginning what has happened.
I think normally they just take it on record. Progress report file taken on record.
No, some judges, of course, normally it is like that, but some judges, of course, if they are curious or if the liquidation is going on for a long time, they would like to know that why this is still continuing, what is happening. Sometimes like that. Otherwise, of course, it is normally taken on record.
Mr. Singhania?
Sir, it's not going to be easy to list out all the events of past progress report when the liquidation is continuing for 3, 4, 5 years. So it's becoming cumbersome and challenging, and it will just add number of pages. Every quarter, you will be again adding the same thing again and again. So I don't think that this is going to make any purpose per se.
E is actually summary information. It's not like details of each action. It's a summary report. It's more like actions taken in the past. Even though it's not required as a
in a liquidation, lot of things happen over a years when it is continuing for 3, 4, 5 years. Even I am handling a cases which is being handled for last 5.5 years and still going on. There are a number of cases in NCLT, then NCLAD, then special court. So if I start drafting this progress report, then maybe I'll take 10-15 days to draft a progress report first time.
Mr. Singhania, but I think the idea basically is not to list out everything, but major events which are of, historical interest, not like every minute detail. So usually, even though the requirement is not there, but normally we make it a point to include previous progress reports also. So as to serve as a kind of reference. But your point is valid. Your point is valid that if all details have to be piled up, the task is only getting more cumbersome.
Sir, one thing can be done is that it can be implemented from the new liquidation assignments. This all these things.
That's a good point.
I think the details under the first point would be in adding up every quarter with the progress report would be filed. So second point obviously would be disclosing the current quarter status.
Second one is new. First one is just a pile up.
Yeah, that will be filed. I think.
But the point that Ms. Singhania mentioned is quite valid, that this may be prospectively applicable to liquidations commencing henceforth, because looking at past liquidations, we may not even have that pile, because, for example, some liquidations are ongoing for several years, and therefore getting that information in proper shape at this stage may be difficult.
Won't be possible, right?
Absolutely, yeah, it's quite difficult. So I think we'll validly make this point that this is applicable prospectively to liquidations commencing after the rate of change. Likewise, I think this should actually be for all the changes with all the progress report recommendations. If anything is retroactive applicable to existing liquidations, will create an issue. Summary of receipts and payments during the quarter. This is quarterly R&P. Well, we're starting with the details the breakup, sale of assets, assignment meaning assignment of any receivables, recovery from receivables, recovery from stat authorities, going concern revenue, contribution from FIs, if at all there is a shortfall, earnest money deposits, miscellaneous receipts. These are the breakup on the receipt side. On the expense side, unpaid CRP expenses, liquidation process expenses, liquidator fee, miscellaneous expenses, going concern expenses, refund of contribution, that is contribution from the FIs, return of EMD, distribution to claimants are the payment items. I think the biggest item mostly will be the going concern revenues and going concern expenses, because that's where mostly there will be many revenue and expense items both, because mostly there is some business continuing, therefore there will be some revenue coming in and some expenses also going there. So this item may require further detailing. So I think you can always add, as they mentioned, also additional ads may be added. So in going concern revenue, going concern expense, you can probably attach a schedule giving more details of revenues and expenses. As for the contents of the RNP, I think personally I'm convinced that these are normally okay. These are like broad heads. You can always give annexures to each one of them. And normally I would like to give, because normally we get it audited, so the auditor also will be comfortable if you're giving further details, disaggregation of the items. Any thoughts on the RNP format? No. Non-fund based expenses as non-fund based exposure of banks during CRP liquidation process. Non-fund based exposure of banks during CRP and liquidation process, exposure at the beginning of the quarter, exposure at the end of the quarter, reason for the change. I'm assuming that these are guarantees given by banks where the CD is the beneficiary. And if there is any change in the process, any change in the number, that's probably what is coming out here. That's item number 2. Liquidation cost, which is requiring further detailing. Mr. Ranganathan, sir?
Actually, non-fund based exposure of banks is from the bank side only. Liquidator will not be having any details in the balance sheet for these items. If at all guarantees is given, it will be in a form of a statement in the auditor report or in the director's report that the company has given guarantees to such and such firms. It will not be quantified in the balance sheet. A liquidator is supposed to realize the asset and distribute it, not to worry about the non-fund bank-based exposure.
I think it's like this. If the CD has the benefit of any guarantee, any of the obligations of CD are guaranteed by banks. Mostly if you're executing a project, there might be a bank guarantee in favor of the CD. So there the CD is not unaware of any, non-fund based exposure. LCs, for example, let's say CD is got the benefit of LCs or guarantees by banks. That is what will count as non-fund based exposure. And the issue here would be that if the CD has, quite often it so happens that the CD will fail to execute a project because the CD was already in the CRP, pursuant to which the contracting party might invoke a guarantee, and therefore the amount of the guarantee may be reduced. So,
in that case, they have to file a claim.
Point here.
In that
I
case,
have
they
a
have to
small
file a
point.
claim only.
Mr. Venkatraman Jayagopal, sir?
Yes, sir. With your permission, may I raise one small point?
Kindly, sir.
See, what I understand is the letter of margin, where the companies give counter guarantee to bank for letter of margin, where the banks give certain letter of guarantee, customs or central excise, that is also will fall into this category.
Counter guarantees, you mean?
Yes.
Well, that's
I think things are coming from the perspective. I may be wrong, but what the seniors, my seniors, and the learned professionals are coming from the perspective of contingent liability, and here we are talking about the non-fund based exposure of the banks. I think those things are coming, which could be of importance, or the adjudicating authority may like to know about the exposure of the CD in terms of what the exposure the banks are taking on it and what kind of contingent liabilities are there in terms of counter guarantees or the corporate guarantees it has given to, to other parties. I think the contingent liability part is coming to the, to the mind of, the people.
Actually, Sumit, it's not contingent liability of the CD. It's liability of the banks towards the CD.
Agreed. So what I'm trying to say, what has been asked is the exposure of the bank on the CD. Right?
Absolutely. Correct.
Right. So what?
Item 2 should be detailed, sir.
Contingent liability part.
It's not contingent liability. It's not contingent.
The item 2 should be detailed, sir. Item 2 should be detailed.
Correct.
So as not to confusion.
Correct. It's correct. Presently, it's not looking very clear. So it should actually be clarified. And just to share that during liquidations, we have actually seen, I mean, there are invocation of guarantees because you're in liquidation, therefore there'll be a failure on the part of the CD to execute the contract or supply goods or services, pursuant to which guarantees are invoked. As guarantees are invoked, the banks file claims thereafter, but that's a subsequent filing of claim. But what is desired here is what's the non-fund based exposure of the banks on a particular CD. I think this is also statistically may be important because IBBI may at some stage collect that also for statistical purposes, fund-based exposure as well as non-fund-based exposure. Then we are looking at item F. So 1 and 2 were both part of E. Then we're looking at item F, which is talking about liquidation cost. And this one is talking about estimated liquidation cost, estimated cost as on LCD. What was the estimate as on the liquidation commencement date? Actual liquidation cost, changes if any in the estimate, and region for actual cost exceeding the estimate. Estimated liquidation cost would have again come as about a preliminary report. Actual liquidation costs already incurred, changes if any in the estimate, and the region for the excess. This is a tricky point because quite often the estimation given at the initiation is, many liquidations may completely go beyond the control of anyone in terms of prolongation of time. So I'm not sure. Well, this may throw a burden of explanation, and therefore one may be required to explain why have the cost increased. But to my mind, it's a little tricky. Mr. Ranganathan, sir. Mr. Ranganathan, you raised hand. Kindly unmute and speak. Anyone else who has any point on this? Okay, Mr. Ranganathan, if you are unable to mute, we'll continue to move. But if somebody has any point, you can maybe speak up.
Sir.
Yes, sir.
With regard to the estimated liquidation cost, it is normally taken for a period of 1 year. Normally. And we estimate it for a period of 1 year so that we think that the liquidation gets over. But for example, if it goes beyond 3 years or 4 years, the explanation, whatever might be the explanation, are we trying to reprimand the RP liquidator by this report?
To an extent, it would amount to at least putting a question, if not reprimand, but at least a question that if you had estimated liquidation to be over within 1 year and estimated the cost to be, for example, let's say rupees 3 crores, currently liquidation is trailing far behind 1 year.
Yes, sir. See, going beyond 1 year is not in the hands of the liquidator, sir. For example, it is due to various reasons, it goes beyond 1 year. It goes beyond 1 year. And this point asking a liquidator, then he has to estimate for 2 or 3 years. Based on this practical experience, he has to do it. And moreover, nowadays, getting an extension for liquidation is becoming an uphill task with the liquidator for reasons not under his control. Even the NCLT benches, they give it for just 3 months, 4 months. When a liquidator asks for 6 months, they give it for 3 months and say that you come back once again. It's unnecessary proving of burden on the liquidator. And moreover, with regard to this cost, it is only an estimate he is making. Other things play a vital role as the liquidation process undergoes. He might not even look at those expenses which he would have forethought, which comes in his way. there must be a proper, guidance in this regard as to how explanation should be given. What is the explanation they are requiring? Whether it was abnormality or was it a mistake on the part of the liquidator? Reasons should be very categorical. That is what my opinion is. They should ask the reasons. What is the reason? Whether it was under the control of the liquidator or whether it was not under the control of the liquidator. Such points of questions must be put in the report so that it is very clear.
I'm completely with you, sir, when you make this point, because this is not like a cost overrun in case of a project. Typically, if I'm estimating, for example, a particular cost for a project and there's a cost overrun, you are required to explain why did the cost overrun. Completing liquidation is dependent on many factors, primarily litigation and the time taken at NCLTs. Litigation also becomes so burdensome because of the time taken at NCLTs. And as the litigation prolongs, there are legal costs. Every time there's a hearing, there is a cost. And those costs, no matter what explanation you can think of, this is something which is completely beyond anyone's control. So explanation always is that liquidation prolonged far beyond estimated, and therefore the costs continue to go up. But I'm not sure if that's the standard explanation that IBBI is expecting. And if that's not the explanation, then what could probably be the explanation for liquidation not being completed within the estimated time for regions which are completely beyond control? So Mr. Kashi Vishwanathan's point is absolutely valid. I'll completely endorse that. Mr. Pankaj Dhanuka, if you have anything further to add.
Just to add here,
Thank you, sir.
The longer the liquidation period is, it is adverse to the liquidator himself, because in most of the cases, our liquidation fees is aligned towards faster liquidation, number one. And the delay in most of the cases is due to legal issues pending with NCLT. And there, most of us appoint lawyers, they are making money, but we are not getting any fees. So
you are losing money.
Whatever the liquidator is doing, he's actually losing money, or whatever is giving time without any returns. So there is no incentive for the liquidator to exceed the timelines.
Yeah, Pankaj, the point is well made. Pankaj, the point is well made. Let me just rephrase that, and let's see if you have anything further to add. We'll probably say that the scale of fees, which is also time based, is itself designed in a way so as to incentivize faster completion and disincentivize delays. So there is a automatic penalty on the liquidator for any delay in the scale of fees itself. On top of that, being asked to explain every time as to why the liquidation is delayed when the reasons are very obvious. And in most cases, the delays are because of protracted litigation or lack of cooperation from the promoters or other connected parties. Therefore, this is additionally throwing a burden on a professional who is anyway carrying the burden of carrying out a tedious liquidation process. So we'll make this mention that this might put, almost like adding insult to injury. They're already injured because of the reduced fee scale, and you are also adding insult on top of that by asking one to explain that. We'll add that point. Sumitji, did you want to add any further point, or you are done?
No, sir. No more point.
Right. Thank you very much. Distribution made to stakeholder. This is basically giving details of distribution: claim admitted, total claim admitted, amount distributed. This is purely a distribution data. So I think that's perfectly okay. Then it requires annexes to be given, which is constitution of stakeholders consultation committee, stakeholder consultation committee meetings, appointment or cessation of professionals, details of security deposit realized or to be realized by each, detail of security interest, which is I think under section 52, details of assets put up for sale during the current quarter, details of assets not being put up for sale during the quarter, details of any PUFE transaction application, details of cases pending before courts, receipts and payments, which is anyway given earlier. Then the annexures are getting detailed here, which is details of SCC meetings, appointment or cessation of professionals. Any point on the professionals appointment? because as per regulations, any appointment of professional requires the vote of the SCC. To my mind, the meaning of the word professional is professionals who are employed by the liquidator to assist him in the process of liquidation. For example, an advocate to represent you before the adjudicating authority will not be a case of a professional, because it's actually not assisting in the process of liquidation, is simply representing your case. Details of security interest realized would be in terms of section 52. And then details of assets put up for sale or assets not being put up for sale, details of any PUFE, and details of cases pending before courts and tribunals, which is once again a list of cases initiated by CD, cases initiated against the CD, and then receipts and payments, which we discussed earlier. This is further breakup of the items of receipts and payments, which we had earlier noted. I'm not sure if there is any further discussion required on the items of receipts and payments. So generally speaking, we have discussed the contents of the progress report. We have given some thoughts on that, and we will assimilate the thinking that participants have given. We will summarize our reports to ICCI IPA, which may then decide how to take it forward to IBBI. I think the whole purpose of a consultation paper is to get the feedback of participants. Pankaj, you want to add anything further? Mr. Pankaj Dhanuka.
Currently, the practice of progress report is we file the progress report after 15 days every quarter in NCLT, and once we file that through an IA, now it is through an IA also, separate IA, correct, and there is a separate listing also. The hearing earlier 1 year back there was no IA, there was no hearing. So now that is there. So well, will that continue? Number one. And this is the format for the NCLT, or this is an online format by IBBI, which is like our monthly reporting, which is an online thing.
Pankaj, look, first of all, we would like to strongly make a recommendation that the practice of submitting progress report with an IA should be immediately dispensed with. This is nowhere coming from the regulation. This came from an order of, I think, Bombay NCLT, and that's where it's probably became common for across the country. It's not at all. Is it going to help at all? Our progress report is filed with NCLT, but why do we list? Why do we make an IA and then make a payment of the fees and then put it for listing? It comes for hearing, unnecessarily clogging the list of matters before the NCLT. Once again, mostly it's the idea basically is NCLT takes it on record. So attaching this as an IA itself, to my mind, is avoidable. We will try to make a recommendation that this practice of filing along with an IA should be dispensed with completely. Number two, we'll make a recommendation that once you are filing, because it's a format, once you are filing, the filing should be actually automatically going to concern NCLT, and there should be no need for the liquidator to file it separately with the IBBI or file it separately with ICCI IPA. Once it's filed on a particular portal, it's auto-filed with the concerned NCLT as well. At least let's have an advantage of technology there. So once you are filling it online, the idea basically is that you should be able to fill it online. So it's auto-remitted to the concerned AA and also copied to IBBI and ICSI instead of duplicating. That's a very important point, Pankaj, and my colleagues will take a note of this and will make a strong recommendation to IBBI to ensure that there is no duplicity there, and plus it's not listed as an IA. This is not helping at all. Mr. T. Ranganathan, sir?
Sir, only thing is whenever it is made online, it's in the form of a software. Actually, when filing the first time, we are facing so many difficulties in IBBI. Whatever reports, whatever they are doing, technical difficulties arise. Even for that, if there is a delay, the fine is levied. Actually, if it is not filed within the stipulated time. So they should be made foolproof. Till that time, you should be allowed to file this copy of the report through mail.
We will make this recommendation also. That until
fine should not be levied unless the software is established.
Right. We will make it.
So a couple of days back, IBBI has introduced the monitoring of this liquidation process through electronic form filing. So
sorry, say it again, Sumit ji.
So IBBI has introduced, the electronic form filing for monitoring the liquidation process a couple of days back. I'm not sure whether people are aware of that. This is the latest thing which IBBI has launched, for monitoring purpose. So the liquidator has to file the, various electronic forms regularly. And filing this, progress report and, monitoring forms. Again, these are adding up, to the workload of the liquidator in terms of compliances, apart from what he has to do in the liquidation process. So any deliberation on that, what kind of value addition would be there, introducing these your progress report formats? Instead of the simple progress report which could have been filed earlier, giving this mandating this content and giving lots of details where at various stages of liquidation. So I'm just inviting the views of the participants here and along with on that.
Sumitji, my view would be, Pankaj will come to you. My view would be that if it helps to avoid duplication, if it helps to standardize a form and it automatically gets filed with NCLT along with ICICI IBA, it's helpful. If I'm repeating the same exercise, filing it standard form with IBBI and then filing it separately with NCLT, attaching a affidavit along with it, signing each page, come to think of signing of pages.
Yes.
Sometimes it end up signing 300 pages in a day. Whose interest is being served by signing each page? I'm not sure.
So
Some NCLTs are asking for each page to be signed.
IBBI has already introduced this in a lateral form filing. I think that should comprise of the details which the NCLT and the other authorities are looking at. That can be, consolidation kind of thing can be done.
That's perfectly fine, and digital signing is acceptable everywhere in the country. I'm not sure why NCLT is insisting on physical signing of each page. This is antiquated, and this is something that IBBI can strongly send a recommendation. IBBI, of course, cannot control NCLT, but can surely make a recommendation to President of NCLT that please dispense with these practices. You asking people to sign every page.
Right.
Mr.
It will avoid duplication of work as well as saves lots of time with the with the NCLT, the lawyers, and obviously the liquidator.
Correct. Pankaj? Pankaj, you want to say something?
Sir, like Mr. Gupta said, there are 4 new forms which have come up. There are 4 new forms which have come up for liquidation. Yes, there would be duplication, but I think this progress report was inserted with the view that earlier liquidator was fully in control, was the sole authority. At that time, SEC voting and all those things were not required. Nowadays, the powers of liquidator has come down. So maybe progress report ka the basic requirement why progress report was there, because liquidator was much more powerful compared to a RP. So now practically CRP and liquidation is same. Liquidator and RP is same. Correct. So this maybe progress report itself may not be worthwhile.
Pankaj, that would be little drastic view to take, because even during winding up, which was also happening under control of the court, liquidation process का you need to, it's almost like आप student का progress report नहीं होता क्या, अपनी studies का progress report देते हैं कि नहीं? It's almost like आपने क्या काम किया, this letting the NCLT know I am working under control of NCLT, what have I done, why have I failed to do what I was supposed to do, that's a different issue, but what progress has been attained, that should be reported. It helps. So I'm not sure whether we like to recommend completely doing away with progress report. On the contrary, I would have actually strongly argued that this process of SCC, multi-stakeholder consultation committee, that to my mind is actually unproductive, because that's diverse interest of people who are actually, they cannot have the same interest. Asking for votes of people whose interests are actually clashing, that's actually making no sense. But that's something that we have, I think, said on several occasions. Today we are not actually on that point. So we would surely recommend that this progress report, if standardized, should actually be electronically fileable and without any signing of each page or without any IA as such. There are some other points which are also coming on the chat, but I would request participants to actually speak it out so that we are able to take
Just a
notes.
small point, sir. Mr. Pakkaji, I mean, I think you mentioned there is no electronic form filing as of now. So IBBI has issued a circular on 28th of June right now. So it
Yeah,
is
I
there.
saw that. Yes,
Actually,
yes,
he
I
did say,
saw
he
that.
said that there are 4
Yes.
forms he mentioned.
Yeah, 4 forms.
Yeah, that's
Okay.
what he mentioned. Mr. Singhania,
Okay.
you would-
In
from
fact,
my mind,
sir, in fact, just to add, in the annexures in this liquidation progress report, copy of minutes which are now monthly required to be done, SEC minutes is not mentioned. I saw that. I usually, as a practice, I attach all the minutes of my SEC also in the progress report, whatever SEC meetings I have done. That annexure is missing here.
there's nothing that stops you from annexing. You can voluntarily, I mean, you do a optional attachments you can always do. Mr. Singhania would like to add something.
Yes, sir.
There are some other
To my
people
mind,
who are.
sir, there was a NCLT circular dated 25th of July 2022, which mandated all the reports to be filed in the form of IA.
Which is exactly what I'm saying. That's actually not productive. How is it helping? I'm not sure.
It's not helping, but that is the.
Let's make a recommendation. Idea basically that we can make useful recommendations. करना नहीं करना उनके हाथ में, हम तो हमारा काम यहाँ पे recommendation देना है, तो हम recommendation देते हैं ना.
Right.
Mr. Avnish Matta, if you would like to maybe, I think you actually.
No, I'm just listening to Mr. Kothari.
Right.
I'm just listening. It's a wonderful deliberations. Always nice to us be listening to you.
Thank
I
you,
just
sir.
was going through and my friend have mentioned about the recent circular. So when I saw those circulars just now, the information what is required in Leak 2 and Leak 3 is almost similar to what is being expected out of the circular. So you rightly mentioned that in case this can be with the technology, if the similar progress report can be taken on record by IBBI for the purpose of this circular, then a lot of effort shall be reduced.
Thank you, sir.
So this is what I wanted to say. Thank you very
much.
Thanks.
And Mr. Rajesh Jhunjhunwala, I would like to speak because you made a chat point. In case you like, because I think the chats will go away the moment we close the chat. I mean, close this particular talk. But if you would like to speak, then we may take a note of it. Otherwise, my colleagues will anyway note your point. You are saying that this should be applicable prospectively only, and otherwise you're saying that this is anyway going to add burden to existing ongoing liquidations, which are going for a long time. Mr. Kashi Vishwanathan, sir, do you want to add any point?
First of all, we should ask for IBBI not to have quarterly reports. We should have it for half yearly. Once in a half year, we have to file. See, already you are burdened with 30 days SEC meeting every 30 days. And think of a situation, the liquidator will be just conducting meetings only. For example, if he's handling 3 or 4 cases, he will be full outcome coming out of it. And apart from that, we have a burden of filing a quarterly report with all these informations and then assimilating and then doing it with no remuneration or whatever you saw. The financial benefit is nothing there.
Right.
There is no financial benefit.
Right. We get the point, sir. Mr. T. Ranganathan, sir, anything further you'd like to add?
With respect to SEC meetings, actually, as per the amended regulation, whenever they ask for extension, we have to give extension by 24 hours. They keep on asking. There is no upper limit. There is no upper limit. They are asking the reason for delay in complete execution. Who is answerable for the delay in signing the minutes? Banks are not accountable either under the CARP or liquidation, or they are not under the regulator. If they have to be strictly put under the regulator. Let them bring an amendment to put the authorized representative and the bank under the IBBI. If they are doing something wrong and against the regulations or against the act, they should be held accountable. Only the RP and the liquidator are accountable as of now.
The point is very valid, sir. The point is very valid. This is a point that we made at several forums, and we like to use this forum also to make the point that in order to make either resolution or liquidation effective, all the elements of the ecosystem, all the agencies of the ecosystem, which includes everyone, I would go to the extent of saying that includes NCLTs also. Everyone should respect timeline. Timeline is not meant only for RPs. The poor RP has to keep timeline. There is no timeline for NCLTs at all. There's no timeline for banks at all. So in order to make, I mean, the process is actually meaningful, there should be timeline for everyone. Everyone should respect timeline. If the timelines are breached, there should equally be a penal provision for every element of the ecosystem. Otherwise, imposing timelines on just one agency and expecting wonderful
sir.
results.
That should be the regulator function is to regulate all people in
all
the
agencies.
not
Absolutely.
just RP and liquidator.
Absolutely. We'd like to make that point here as well. Well, it's been
Excuse me, sir. Am I
Shanta
audible?
Lakshmi?
Yes,
You
sir.
are, ma'am. Yes.
Sir, actually, I'm basically an advocate and insolvency professional. I've completed 2 liquidation process, sir. And those 2 companies have been dissolved. Okay, now I have to update the MCA portal with respect to the dissolution of the company. I tried my level best in filing the form INC 28. Since I am not professional registered with the MCA, like CS or CMA, I am having some difficulty in filing form INC 28. Now, after couple of months time, I come to know that there is some mistake in my PAN card itself. At the time of registration, I got my PAN card in 2008. Now I'm finding it like some change in the initial or spelling mistake, something. But because of that, I am unable to file the form INC 28. Now it is more than 2 months delay caused in updating the dissolution order with MCA portal. So it means like they will be charging, I mean, penalty will be imposed for the delay cost. I have actually sent the email with attachment of dissolution order to the ROC, and also I have physically submitted the copy by visiting the ROC office, Chennai office. But they are saying it will not be considered at all. Only the way to intimate to the ROC is by way of filing form INC 28 only. But till date, I am unable to file it. For those 2 companies, it is still pending. In this kind of situation, there should be a circular to the ROC in this regard. If there is any such delay beyond the control of the insolvency professional, during the exceptional cases, that physical copy or email copy can be accepted.
Ma'am, I think the best way would be to intimate the liquidation division of IBBI and ask them to help you. I think they should be able to help.
Oh, okay, sir. I will do that.
They're quite helpful people, very helpful. So you can maybe write to them, explain the situation, and then they may then interact with ROC and try to find a solution.
In fact, sir, in some cases, ROCs are accepting the hard copy from backend to give
but
effect to the.
Maybe Chennai ROC may not be. So I think best is to liaise with IBBI.
Before introducing V3, they were also updating the backend. Now they say it is not in their hands, and they are also helpless.
Sure. I think maybe liaise with the IBBI. They should be liquidation division of IBBI. They should be able to help. I think it's been a wonderful discussion.
Thank you,
ma'am. Thank you very much. It's been a wonderful discussion with all of you. ICICI IPA, thank you for giving us this opportunity to interact with more than 150 people, which is so very commendable. We thought the topic is not very interesting, but 150 people have decided to join. So that indicates the level of support that we have from all of you. I would pass the mic back to ICICI IPA.
Thank you, sir.
Thank you, everyone.
So much.
And thank you, sir. ICICI IPA, can you maybe take the proceedings?
Thank you very much, sir. Thank you all the participants for having such an interactive discussion. And sir, I request you to please share the pointers with us also.
Yes,
so that we can also forward the same to IBBI on our behalf.
Absolutely. We have noted the very, very useful and very extremely enlightening comments from the participants. We will send a summary to ICICI IPA, and then you can decide what to do further. Thank you very much, ma'am. Thanks, everyone. Thank you, everyone.
Thank you, sir.
Kothari, thanks, Mr. Kothari and
Thanks.
ICSI.
Thank you very much, sir. Thanks. Thanks a lot.
Thanks everybody. Thank you very much.
हमारा काम तो उसी हिसाब से है